Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020. 7:44 p.m. How does the FBI find people? The people is misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
It's bigger than you. It's bigger than me. It's bigger than all of us.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. There I am. We're getting started. We're going. We don't have time. Greeners, congratulations. You are, my friend, are first in chat. The internet's all yours. Keep it running for all of us so we won't complain. Otherwise, trust us, we will. We will complain. Thank you, Greeners. That's like 3 out of the last 4 live streams Greeners won the internet on. I think he's on a roll here. So, all right, we're going to jump in as we slowly fade the music out here. We have to tell you where we are. Don't miss the forest for the trees. Where we are in this trial, we are in closing arguments. Earlier today, in the previous live stream. So if you're just watching this on replay, previously today we watched a portion of day 3 in the North Dakota versus Nichole Rice trial. During that video, we watched the first 10 minutes of the opening of this closing. And why do we watch the first 10 minutes? Well, because it was happening right then, and it turns out the defense, who opens first in this case, in their closing, who goes first, got interrupted by a medical emergency in the gallery. Jason's dad had a medical emergency, collapse of some sort. Somebody said, "Help, can I get some help, Dad?" You know, they're yelling. And, of course, Jason turns around, and bailiffs are scrambling, and the medics were called, and he was taken away in an ambulance. So that happened, and then we got this break. They paused for about an hour or so. So we were a little bit behind trying to catch up. But we're going to be jumping back in right now. If we can. There we go. Give me a minute. We'll get our counter reset back to how many curses there are. And I think we're at 73. It's a lot for this trial, 73, and all of them were the bomb. Okay, counter's at 73. Let me get the graphics in as well.
Counsel, can you approach real quick?
Nice quick approach. Great way to start everything off. While we're doing that, I'm going to go ahead and put this on 1.25 speed because we have a little bit of catch up to do. And quite honestly, they talk slowly. So 1.25 speed it is. There we go. Trim up the box on the bottom so it looks good. There we go. Perfect. All right, we'll give them just a second to get whatever it is they're hammering out done. The latest we know is he was taken to the hospital. I don't know anything beyond that facts-wise as to his status. One of the toys I got today, well, not toys, one of the tools I got today was from a company called DJI. I know it was not a drone. It's a gyro-stabilized gimbal to stabilize my phone for when I am out doing like a pole cam stream, so it's not so shaky. All right, here we go. There's Samantha's. Thank you, Samantha, by the way. I appreciate your comments. We should be resuming closing arguments. They get an hour each. We're going to probably watch both of these back to back, and then resume North Dakota later this afternoon.
Please rise for jury attendance.
We'll be working right up to the podcast, I think.
Please be seated.
Okay. Thank you for your patience, ladies and gentlemen. These things sometimes happen during trials. As my staff informed you, the gentleman who had the medical incident during the proceedings is doing well and has been seen by medical staff. And so at this point, we're going to reconvene. Obviously, what happened in the courtroom has, as you can imagine, has no bearing on your decision in this case, one way or the other. So I ask that you not give any further thought or consideration in terms of your role as jurors in this case. And so we're going to continue with Attorney Sister's closing argument.
No sympathy for the defendant.
Thank you.
Because his dad collapsed.
Thanks for hanging in there. I was telling these guys, you got to see me do what I used to do a long time ago. Okay. He's okay. All right.
He's trying to get more mileage out of that.
Okay, let's start this again. I'm not going to go over this for a second right now. I want to get back to the very, very basic principles of why we're all here. And basically, why we're all here is to give Jason a fair trial and to follow the principles of law as they were outlined to you by the judge. And we'll go right back to the beginning. It was proof beyond a reasonable doubt, burden of proof, presumption of innocence, and then, folks, the additional thing in this case was self-defense. And you all got a grasp of what that was. And you got to see some of it during the course of the trial, and now I'm going to try to explain where we are with this thing. Okay? Like I said, this is an interesting case. It's a self-defense case. There's no question about it. And there's some very graphic material in here, very graphic medical material. You saw that video, and you heard about what was taking place. They're heroic medical procedures, I can assure you, that kept Kyle alive. And he was very lucky to have a combat-trained individual on scene at that point in time. That's all I can tell you. And he's alive. So the gory film that you saw, frankly, is not at issue. The injuries were very significant. Okay, there's no question. Gunshot wounds themselves are very significant. These were very significant. But this is a rare incident, folks, where you get to see somebody, in this case, Kyle Violet himself, the centerpiece of the prosecution's case, in a situation where not only was he threatening on April 5th, something that he had done before with Jason, and I'll go back to that, the October incident, for no reason at all, the threat to his life, the threat to his family's life, right in front of his own home, for no reason at all. And we almost have an instant replay of that. But this time it's even more bizarre, because this time the claim is that he's plowing snow into his driveway or something to that effect. The beautiful thing in this case is that you have some film that you can actually look at. And if you look at it, Jason is actually being extremely careful in the plowing, not to interfere 1 inch into Violet's driveway. And he's minding his own business. Now, Jason had gotten up on April 3rd at about 8 o'clock. By the time you see him plowing, all right, he's already into about his 38th hour of being awake, of working, not just being awake, but working. Now let me suggest something. When you go back into the jury deliberation room, you may want to do this. You may want to take a poll of everybody back there and ask who back there has been up for 38 to 41 hours in a row, ever, in their life. Ever. Ever. You may want to say, if somebody does raise their hand, how did you feel? Did you feel with it? Were you working during that particular period of time? Were you in a combat situation? Just what was it? Were you in the comfort of your dorm room or your home? Get the context. But I assure you, if there is somebody that was up that long, they will tell you that they were worth pretty much nothing mentally, pretty much nothing physically at that point in time. You can all relate to that. I mean, There's nights where you just want to go to bed, even though you've been up for only 15 hours. This is more than twice that length of time. So when Jason is confronted by Kyle Violet on the evening of April 4th, 2024, we know for sure from the video that Violet initiated the contact, and he literally, physically assaulted Jason. He placed his face intentionally on Jason's face. Now, why would somebody do that? And again, what would a reasonable person believe if somebody did that to them out of nowhere? Well, Violet did it to threaten him. The physical act alone was a threat. I mean, imagine that. Imagine somebody coming up to you out of nowhere and sticking their face right onto your face. But it's not just sticking his face on your face. It's threatening him at the same time. And it's threatening him at night while he's minding his own business, at his home, with his daughter in his truck. That's the context. That's the very context of when this starts. That's the alpha. That's the beginning. Kyle Violet really is the alpha and the omega of this case. He started this. You know, you wouldn't be sitting here at all. Think about this. You wouldn't be sitting here at all but for Kyle Violet. Why did everything go down like that? What was that scramble all about? It was all about Kyle Violet. He placed himself in a position intentionally to threaten Jason. To threaten Jason with death. There was nothing conditional about sticking his face on Jason's face. And there was nothing conditional about threatening him. And you'll see that it happens more than once. When you run that video, you take a look at how many contacts he had with him. I mean, what was he trying to prove? What in the name of God was going through his head? Other than to try to scare hell out of Jason Levesque. And to relive that same threat that he'd had with him months before. And again, it was for no reason whatsoever. None. Zero. So we know that he initiated the contact. We know that he stuck his face into Jason's face. We know that he made threats. He made multiple and multiple approaches. Now, I'm going to ask you, I'm going to go through self-defense instruction in a second, but I'm going to ask you, do not abandon your common sense when you sit here. When you looked at that, what did you see? Did you see some cool, calm guy coming out to say, please move some snow, please don't block my driveway? Or did you see an enraged, out of control, insane guy coming up on somebody minding his own business in the middle of the night? And that's the context that you have to take this case. And you're going to hear from the judge that you have to basically run it through the lens of what was going on that night. Not today, when we're all sitting in a courtroom,
Deanie, text me a burner phone,
rolling it over in our heads and going frame by frame like Detective Dan did. Because that's not reality. The reality is that this whole interaction took about 11 seconds. This is quick stuff. Quick decision material. With a man...
Okay, remember that. 11 seconds.
That he was even going to run into Kyle Violet that night. There was no reason for it. Reason means something in this case.
11 seconds.
You think for a second that Kyle was not threatened. I'm sorry, that Jason was not threatened.
Oops.
Then you got to think of it. Anybody would have been threatened in that situation. Anybody would have been concerned about protecting themselves. Anybody would have been concerned about protecting themselves when somebody's saying that they're going to kill them, or kill their family, or both. That's the context that we're dealing with. That's the case. That's the case that I mentioned. But frankly, it's more than that because Kyle, he wouldn't give up. If you look at the video, he walks away, and you'll see his arms all over the place. You know what's going on there. And you see Jason standing still, doing nothing. You've got one madman screaming at Jason Levesque, doing nothing. And then he starts back at him. And that happens a couple times. And the last time he comes back at him, he's screaming at him and he's telling him, you don't know me, you don't believe it? The threats keep coming. Threats keep coming. And I'm going to ask you something. Okay? How many times do you have to put up with that? Do you have to wait until somebody comes at you with something? You know, Jason Levesque didn't have the wonderful experience of what the deputies do in this courthouse when you enter through the front door. And that is check people out, see if they have any concealed weapons or metal or anything. He had no idea what he had. None. And you'll hear in the instruction that he doesn't have to even be threatened with a weapon. All this questioning about, did you see a weapon? Does he have a weapon? When you got there, did he have a weapon? Guess what? That's a mirage. That's a mirage. All Jason has to believe at the time is that somebody is out to kill him or cause serious bodily injury at that time. Not 5 hours later, not 2 hours later, not 2 minutes later, certainly not a year later, but at that time. What would a reasonable person believe at that time? After somebody who had threatened you months before for no reason, and then came out of a house and threatened you again for no reason, and threatened death to you, was coming at you. What would a reasonable person think? Think something good was going to happen? Think they were going to talk it out? He was violent, he was threatening, and he was out of control. That's what cop. That's what you were dealing with. That's what Jason was dealing with. You know, you can put as much lipstick on a pig and earrings and bracelets and everything else that you want. But at the end, it's still a pig. Kyle Violet is no innocent human being. He bears the brunt, starting this thing, creating the situation, and the reaction from Jason. He bears the brunt of that. Nothing would have happened but for his behavior. Nothing.
New polls.
Now, in this case, you got to see a breakdown, and you heard testimony from Detective Danny. And remember, he got to go frame by frame. Remember what he was doing? It was kind of cool, but I mean, it was frame by frame, and something that, of course, Jason wasn't able to do. I mean, retrospective observations are interesting, all right, but that's not the test. But I'll tell you something very important. When you do frame by frame and you listen moment by moment of what you can hear, it may be very, very telling as to what was going to happen. In fact, Angela LeChant was almost a prophet of what was going to happen that night. And she took the stand and she raised her right hand. She swore to tell the truth. And she made something up. Right here in front of you. Not after a traumatic event. Not after over 40 hours of being up. Not after 24 hours of work. She made something up to skew the case, to hoodwink you guys. Angela LeChant, Kyle Violet's significant other, made something up. I'm sitting there wondering, is the prosecution going to hug what she said and urge you to believe her during their closing argument? I think not. Because what she said, in coordination with the video, is basically the prediction of the future that took place just seconds later. What she said is impactful. It's her present sense impression of what's going on with Kyle Violet. That's her watching her significant other going down the driveway and confronting Jason. And Detective Danny captured him. In fact, at 10/11/22 on the 4th of April, 2024, Angela LeChant is heard saying, quote, "Yep, there he goes. I don't know, he's all the way out there. He better not do anything stupid." Now what's this stuff? Who do you think she's talking about at that point? It can only be one person. It can only be one person. And that's Kyle Violet. She's watching her significant other, and you'll see it in the video, coordinating with her speech, going across the driveway, and approaching Jason. And just a few seconds later, Angela says, you better not do anything fucking dumb. Who do you think she's talking about? Jason's just standing by the truck when she says that. Who is in Jason's face? Kyle Viola. No, that's black and white. That's obvious. That's obvious. But she still had the gall to tell you, no, I was actually talking about Jason. And that's absurd. That's ridiculous. And frankly, if you want to know the definition of a lie, that's a lie. That's a lie. That's an intent to deceive. That's an attempt to put a thumb on the scale and try to convince you guys of something that just wasn't happening. That's just something that's out there in outer space. That's Angela. That's Angela Legit. What really happened that night, she could almost tell was going to happen. Somebody was going to do something stupid. And you saw it. Now, in the self-defense case, there are many, many items you have to go over, and this instruction is going to help you out. Okay. And the judge is going to tell you that evidence has been presented that the defendant has acted in self-defense. When there's some evidence of self-defense, the state must prove beyond a reasonable doubt that the defendant did not act in self-defense. I mean, that's a heavy, heavy burden, okay? They have to disprove self-defense beyond a reasonable doubt. If you have a reasonable doubt as to whether the defendant acted in self-defense, you must find the defendant not guilty. If you believe, in other words, that his reaction and his actions that night were centered around self-defense, then it's a not guilty.
That's
Clear.
a misstatement of the law. Not centered around
And deciding,
self-defense.
this is critical now. You're going to hear it again, and you're going to have this instruction. In deciding whether the defendant acted in self-defense, you should consider all the circumstances surrounding the incident.
All?
All the circumstances surrounding the incident, which include the prior threat, all the work he did that day, his exhaustion, the fact that he was put upon by surprise, and that he was threatened. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. So you have to step back. You have to see how he would have been seeing things at that time. Okay? Not under a microscope, not after, clear, detached reflection, none of that. But at the time, these things happen quickly. And that's why this particular instruction is important. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. Not coolly and calmly, right? Not rolling it over in his mind, but reacting to what was presented to him at the time. It gets better. A person has the right to use deadly force on another person to defend himself or a third person if three conditions are met. He actually believed that the other person was about to use deadly force against him or a third person. It doesn't say that he thought the other guy had a weapon. It doesn't say anything like that. All this weapon stuff is an illusion. He doesn't have to risk him and see if he's got a weapon. In other words, the defendant can use deadly force if he actually believed that he or a third person was in imminent danger of death or serious bodily injury from another person. Serious bodily injury, ladies and gentlemen, can be as much as a sucker punch from a madman that breaks your nose or knocks you to the ground or whatever, okay? And folks, if you were looking at that film objectively, it almost looks like it could have just happened any minute. Any second, forget about minutes. There's a definition of serious bodily injury. For purposes of understanding self-defense, it means any harm to the body which causes severe, permanent, protracted loss or impairment to health or function or any part of the body. Not a bump or a bruise or a scratch. We're not talking about that wouldn't constitute serious bodily
Where
injury. As the words
where are you
imply,
gonna
serious
vote,
bodily
Nichole?
injury requires a serious or
We're
significant
going to
injury.
close it soon.
Could he anticipate a serious bodily injury? Yeah, when somebody's threatening death, you can kind of get to that spot. Even if the defendant actually believes that such danger existed, that is, that either he or some other person faced an imminent risk of either death or serious bodily injury, that belief must have been reasonable. I'm going to stop right there. You saw everything. You heard everything. You understand what's going on here. I don't want to be preaching to the choir too long. How could he not have a reasonable belief that this maniac meant what he said? When he came back at him the last time, he said, "You don't believe me?" In other words, there must be reasonable grounds for the defendant to believe that the other person was about to use unlawful deadly force against him or a third person. And here's the key. Self-defense does not require an actual danger to the defendant. Rather, the defendant must reasonably believe that the other person was about to use unlawful deadly force. Again, check that box off. He must reasonably believe that the amount of force he used was necessary for self-defense. You know, he said on and on and on and on and on, that he was trying to protect himself, that he was trying to protect his family. Look, I'm going to get into his testimony in a second. But to the police even that night, in the condition that he was in that night, that's what he was saying. A person's not permitted to use excessive force in self-defense, only a reasonable amount of force. And again, this has to be interpreted from at the time that he was perceiving these events. The defendant can use the amount of force which he believed was necessary under the circumstances, as long as, at the time, there was reasonable ground for his belief. Folks, reasonable. One can very easily come to that conclusion, that his reaction was reasonable because he was put upon by an unreasonable human being. That he was put upon in a savage situation with threats of death in the situation that he was in. Let me tell you something, okay? Jason went through quite a bit that night. Not only was he exhausted, not only was he threatened by this maniac, but he was trying to care for his daughter as well. He was worried about his parents. Of course, he was worried about himself. And he was exhausted. So what happens after this thing happens? Is it somebody saying, "Oh my God, I'm going to run"? No. Actions speak a lot louder than words. Jason Levesque stayed right there. He didn't make one move to leave. There may have been an off-cuff comment to his daughter that, quite frankly, is stupid and doesn't really amount to anything. He never tried to evade the police at all. In fact, there's evidence that he even dialed up 911 and just didn't hit the button because he heard the sirens going. It came from him, it came from his daughter.
If you voted, please click the like button to let me know you're done.
He stayed there.
Thank you.
It also speaks to the fact that he made the firearm safe. He prepared for his arrest. He placed the firearm in the dash. He took the extra magazine out of his pocket. He secured that. And when the police came, he stepped out of the vehicle, he raised his hands, and he cooperated all night long with the police.
He shouldn't have said he prepared for his arrest.
That's not somebody with a guilty conscience. That's somebody that's waiting and anticipating and then cooperating with the police. Just like an innocent person would do. No resistance, no lip, no nothing. When they asked him to get in the cruiser, he got in the cruiser. When they asked him if he could go to the police station with no problems, he went. And we got to the police station, folks. You saw the video clip. I want you to watch that video clip. About 20, 25 minutes long. Okay? And in the video clip, you're going to see a human being, all right, that is wiped out. I can't even describe it. This guy can hardly take his own sweatshirt off. He's cold. He's hot. He's nauseous. He's laying down on the floor of the interrogation room. That's just the beginning. There's almost 3 more hours of that. you think he got better over time? Do you think that's a good environment to get factual, actual, accurate information from somebody? Be surprised if he could tie his own shoes at that point. But they took a statement from him, a lengthy statement, and he was sitting there as long as they wanted to take it. This isn't somebody giving him lip. This isn't somebody that's resisting. This isn't somebody that's uncooperative. This is somebody like just what he said on the stand. He was just trying to help put it all together. Do you think somebody actually has a vivid, accurate memory? I should have drawn this a little bit. After being involved in a shooting? For the first time in his life, by the way. I mean, this guy doesn't even, like I said, he never even shot a chipmunk in his life. Do you think that doesn't shake you up? Do you think that doesn't scramble you? Do you think if you add that to the threats, that doesn't scramble you? Do you think if you add that to the fact you've been up for 40 hours, that doesn't scramble you? Do you think if you add that to the fact that all you're getting is a glass of water and a Slim Jim, that doesn't scramble you? That's the context of the 3 hours, over 3 hours, of interrogation with Jason. But did he complain? Did he say, no, I don't want to do it? No. In fact, the entire night, this guy is cooperating with the police. Can we search your truck? Yes. Can we take your video info? Can we take your cameras? Can we take your hard drive? Yes. Can we have the password? Yes. Okay? Yes, yes, yes. Will you speak with us? Yes. Can we swab your hands? Yes. Everything's yes. He's trying, okay? Was he perfect in the interrogation? No. And you know what? Nobody would be. Not under those circumstances. Nobody would be. The honest answer to that, he's doing everything he can, not only to help the police, but he's doing everything he can to try to explain what went on that night. He tried to do it with you guys. And you know it. He didn't have to take the stand. You know that, right? He didn't have to subject himself to cross-examination, and Attorney Barr's very good at it. Been doing it for years. He's very good at it. He didn't have to do that. He didn't have to put up with that. Nobody forced him to go up there. Jason Levesque went up there because he wanted to look at you folks in the eye and tell you the best he could as to what happened. Not skewing the facts, not lying, not deceiving you, not playing games, not changing stories. Is it unreasonable, for instance, for somebody in that situation to not remember each and every time he pulled the trigger? It's an automatic. It goes on automatic. He's pulling. It's not done till it's over as far as he's concerned. And what's his concern at the time? Protecting himself, protecting his daughter, protecting his home. This thing happened right on the front steps of his home. Right in front, pretty much, where his mom and dad were sleeping. Right there. No lies and deception. That's a red herring. I'm going to urge you to take your time when you're deliberating. I'm going to urge you to listen to everything that's going on in those tapes that you have. Watch everything that's going on in those tapes. Okay. You know, Detective Garston spoke of tactics and training and all this stuff for interrogation. Maybe he was running an interrogation with tactics and training and everything else. Jason Levesque, he's not sitting there constructing a self-defense defense. He's not constructing anything. He's trying the best he can to cooperate with the police after a traumatic incident. A first for him. Shooting anything that was living and breathing.
I'm going to close out the poll here. Last call.
And you'll hear Garston. You'll hear him in that tape. Listen closely. When his body cam is not switched off, and he's talking to another officer. And he says, let's talk to this guy now. Let's talk to him now while he wants to talk. Okay. They got him in their place. They got him while he's exhausted. They got him while he's easy pickings. And you know what? They know deep in their heart, they got a very frail human being that probably isn't going to be the best person in the world to get accurate information from. They could have circled around 5 more times and probably gotten 5 more answers. Because even yesterday, Jason's not sure exactly what happened that night. You know why? Because the body tries to stop remembering things like that. It protects itself. It goes into shock. It tries to get rid of memories like that. And those are difficult to bring back accurately all the time. There's nothing unusual about that. Any trauma situation, there's nothing unusual. It's typical, it's human, it's natural. Some of you may have experienced this. Prosecution, in this case, for lack of a better analogy, was dealt a lousy hand. In order to get a conviction in the United States of America, in a courtroom like this on a criminal case, you got to hold aces. You got to prove the case beyond a reasonable doubt. Okay? No goofing around. No halfways. No maybes. No probablys. No could-haves. None of that stuff works. The only way they get a conviction in this case is to prove beyond a reasonable doubt each and every element of the offense charge, each and every one, beyond a reasonable doubt. And they have to disprove self-defense beyond a reasonable doubt. And in this case, ladies and gentlemen, they got dealt a lousy hand. They don't have 4 aces.
Meg, thank you for upgrading.
You flip their hand over, what they really have is a bunch of jokers. And the joker in the case is Kyle Violette. They got dealt Kyle Violette. And when you get dealt something like that, that's a gigantic reasonable doubt. And when you get dealt somebody that acted the way he acted in a self-defense case, that's a lousy hand. But don't feel sorry for him. This isn't about sympathy. It's not about worrying about their case. It's about critically analyzing their case and making them prove their case beyond a reasonable doubt. You have to make them prove it. And if they don't, you understand that in the United States, you're doing your duty. You're doing your duty by coming through the doors of the deliberation room at the end of a trial and at the end of running through all the evidence, coming through and saying not guilty. That's the justice in the criminal justice system. It's not doing favors for the state. You don't do that. It's holding them to their burden. And I pray you do. I mean, there's a lot of junk that's going on outside of this courthouse. You all know. I mean, our country's divided all over the place. All kinds of junk going on.
Pickles, not politics.
Maybe the purest form of being a citizen right now, the purest form of being a citizen in this country, the purest form of democracy in this country, the purest form of doing your duty as a United States citizen in this country right now is in courtrooms just like this, with jurors just like you. Think about that. You're really the reflection of this community. You know that, right? When you go back there, you're going to see you come from all different walks of life. You all have your own talents, you all have your own backgrounds, and you all have common sense. And if you all work together in this case, if you all put your minds together, all 12 of you when you get back there, you're going to come up with a very just decision by using your common sense, looking at that evidence, being critical of the state's case, and following the rules. So, ladies and gentlemen, I'm going to ask you. I can't do anything anymore for Jason. I can't do things. And all I'm doing is putting all of my trust in you guys. And so is he. Okay. So really, take great care in your deliberations. Be sure to follow the rules. Take all the time you need. And thank you again. I appreciate it. Really. Thank you.
Okay. He says 11 seconds. It took place in 11 seconds. 2 or 3 of those seconds were between the first and the remaining 5 shots. All the rest of that time, think how many times he said, "I'm going to kill you and your family." or at least how many times we were told happened in those 11 seconds. It doesn't add up. It doesn't. Might have to slow it down here if he talks too fast. We're still on 1.25 speed.
I want to talk about two words that were touched on in that presentation. But I want to talk about those two words in the context of the shooting. Before and when Jason Levesque decided to shoot. And this isn't a case just of a shot. This is 6 shootings. And I want to talk about these two words in that context. These two words are reasonable and imminent, as about to. And to be clear, these are not just words. These are the concepts and principles of a sensible law that buttresses against inappropriate and unnecessary deadly violence. Violence driven by notions of retribution, revenge, impulse, anger, and poor judgment. We guard against that with these concepts. These principles exclude unnecessary and pointless violence, but they also at the same time ensure for you, for me, for everybody, including Jason, the right to protect yourself, but within the boundaries and scope of reasonableness, reasonable force, reasonable belief of impending deadly force, reasonable degree of force to respond to imminent use of force, deadly force against you. That's the framework that needs to guide your analysis of the evidence. And that's what I'm going to talk about. Let's move on to evaluate really each chapter, each motion through this process. Not to dissect, not to impose some unreasonable analytical approach to Mr. Levesque's choices, but to assess his choices and his actions appropriately. Evaluate each one of these steps, these sequences, and you'll see that at each stage, after the initial confrontation, there is actually a cascading sequence of diminishing risk. From the moment Kyle Violet stepped away, there was diminishing risk. And I want to ask you to evaluate the steps in this case concerning issues like distance. Distance creates safety. Evaluate it. Distance can be closed and increase risk. Distance creates opportunity to assess risk. So at each one of those chapters of this case, consider that as a factor. The time. Attorney Sisti said this whole thing happened in 11 seconds. You'll have the totality of the videos. It took more time for Kyle to walk across from his driveway over to Justin. I mean, to Jason. There was 5 seconds between, nearly 5 seconds between that first shot. 2001, 2002, 2003, 2004, some 5 steps towards him before he unloaded the remaining 5 rounds into his back. Consider that distance and time when you assess reasonableness. Visual opportunity. The opportunity for Mr. Levesque to assess risk. The lines of sight here, the lighting. Remember at the beginning, there was one moment in Attorney Sisti's cross where of Detective Danny were saying, look, you don't even know whether or not Jason is able to see his hands because of the lighting. And yet, we see a video from 43 where inside, from 40 feet away at least, Angela's able to say, he's got a gun. The lighting in this case was very good. Illuminated by a high-density residential neighborhood with exterior lighting. You can see it in the video, a truck with its headlights on. And Angela having no problem identifying immediately when the gun was taken out, when Jason produced the gun, which informs you about Jason's ability to assess whether or not Kyle was armed. And so those are some of the issues to talk about and consider when we actually walk through this. And let's do that now. This confrontation starts when Kyle walks out of his home. And despite Attorney Sisti saying at some point challenging Danny that Jason doesn't even seem to know he's there until he's at the plow. We know this, that when Kyle was walking out of his home, Jason did see him. He had a full opportunity to view him from the full 40 feet here. You were out there at that scene. You know that distance from the far end of Kyle's driveway all the way over that plow. And we know he saw him because he told the police, I saw him putting on his shirt. You don't have to believe him. It's corroborated by the video. So we know he saw them at that point. And what does he see? He's putting on his shirt and he's able to describe his hands. You know, this is an informative moment about whether or not there are reasonable concerns about Kyle's ability to cause violence of such a degree that would justify what happens next. And nothing in his hands. You can see him putting on his shirt. There's nothing underneath. No reasonable basis to believe that he's armed coming over. Jason admits that he can see his hands, that there are no weapons, that there's no means of imminent threat as he's walking over. And let me just address this one point that Attorney Sistis said, that no weapons is just an illusion. It's a red herring. That's nonsense in a case like this. It's true that there's this phrase in the instructions that say, look, he doesn't actually have to be in danger. But that means if somebody presented a firearm that was carved out of balsa wood and painted black, the actual threat of that is zero, but the perception of it could be reasonable. That's not this case. There still needs to be a reasonable apprehension that Kyle had the means, the ability to cause lethal, deadly force. And obviously something like weapons is highly relevant to that reasonable analysis, is it not? The face-to-face encounter. It's clear that there is contact. Jason's description of it actually says the tip of his nose touched my cheek. Let me be clear about that. There's nothing that's sort of appropriate. I'm not suggesting that's a good deed. Let me just clarify this point. It's non-deadly force. There's no suggestion that he is going to kill him with his nose. I don't mean to sound glib about that. I mean literally to say that dismissing that he didn't have a weapon and say that the encounter there is what drives this analysis is misplaced. Here's the reality. That moment passed without the use of deadly force. That's not when the shooting happened. And yet, in this courtroom, that is what was recreated by the defense. We literally had a recreation of the face-to-face, the nose-to-nose encounter. And you know what we never got to in that presentation, that recreation, was when he took out a firearm, closed the distance, saw Kyle stop, turn, and shoot him in the head, lower the gun, and then advance on him and shoot him 5 times in the back. We didn't see that recreation, but that's what this case is about. It's on tape. That's an ace. Each one of those videos is an ace.
Is he doing a tennis move there with the ace?
You know what could have happened at that nose-to-nose assault? That's the definition of non-deadly force. And you know what Mr. Levesque would have been fully within his rights to do? Shove him. That is to use non-deadly force in response. That is another corollary of self-defense. You can defend against non-deadly force.
Boop him in the nose.
With non-deadly force. He may have even deserved a punch in the nose. Reasonable force. But to bring that whole episode forward as justification to shoot him is not reasonable. It is the most intense moment of this entire episode. And yet, that's not when he was shot. And that moment was defined by non-deadly force. His hands were out. He had no weapon. He didn't claim to have a weapon. He didn't hint he had a weapon.
They have 5 aces, which may be a problem.
Even in that moment, there was no reasonable basis. If he had shot him, would have no reasonable basis to do so, and he didn't. The moment passed. He made a threat. We accept Jason Levesque's characterization of that threat, repeatedly made to Detective Garston. Never wavered about that. Not too tired to use the term, that was verbatim. Not too confused to say those were the exact words. Not too confused to repeat the conditional threat over and over and over again when Detective Garston revisited those issues to do his looping. Tell me what he said? Every single time it was a conditional threat. I want to talk about that. let's be clear. If words are the basis to justify killing somebody, then words are really important. A conditional threat, these aren't just legal concepts, I gotcha moments from the law. These are common sense analyses of words. A conditional threat is important, it's different, because it literally buffers and defers both the act and a time period of when a threat may come to fruition. I know that sounds all legalese. Put it this way, something needs to happen, and it's going to happen in the future. And that diminishes the nature of the threat. It's not,
show off, but
I'm going to kill you for what you just did. That's imminent. Brandish a knife. I'm going to kill you for putting the snow next to the pole. It didn't happen. Something else had to happen. And it would happen in the future. And then, still, Kyle would have to have the means to actually do something lethal and violent. I mean, there's some pretty common sense examples of this notion of conditional threat, from this, the real world. If you flirt with my girlfriend in the gym one more time, I'm going to kill you. The guy says, fine, I'm not flirting with your girlfriend, I'm not going to do it anyhow. If you cut me off in traffic one more time, I'm going to kill you. It's a conditional threat. I'm not going to kill you for cutting me off. It's different by nature, by assessing reasonable risk. Let me just talk about this condition too. You want to know what the biggest red herring in this case is? It's where Jason Levesque put the snow. That's actually the point. Attorney Sisti got up multiple times to point out with different witnesses, hey, that's not on his property, is it? No, it's pretty close. You heard from a bunch of different witnesses. No, not on the property, on his property. That's the point. The condition of the threat hadn't happened. And Kyle is literally saying that. He's not saying you put snow on my property, therefore I'm going to kill you. He said, if you drag that stuff out of your driveway and push it down in front of my driveway, then we got this problem. Didn't happen. According to Jason, it wasn't going to happen. And that literally redefines the notion of this threat. That's the point. It didn't happen. You can actually see Kyle continue to explain the conditional nature of it when he walks away from this nose-to-nose encounter. He's pointing at that snow and his own driveway. That needed to happen. And it diminishes any notion that Kyle Violet is about to act on anything. The law actually recognizes this distinction. This notion of complying or not complying with a threat. Here it is. This is in the justification of self-defense statute. A person is not justified in using deadly force on another to defend himself or a third person from deadly force by the other if he or she knows that he can comply with a demand that he or she abstain from performing an act which he or she is not obligated to perform. That's a very legalese definition of conditional threat. In other words, if you don't have to perform this pushing snow in front of the driveway, of Kyle's driveway, you can't use reasonable force. You can just not do it. Here's the difference. If somebody comes up with you with a knife and says, look, give me your wallet. You don't have to comply with that. You can take your gun out in the face of a knife, in the face of the threat of something that you don't have to do. You shoot them if you want them. Somebody comes up to you with a knife and says, hey, look, if you ever come into my home again and steal my wife's jewelry, I'm going to kill you. You don't not only have an obligation to go into their house, you have an obligation not to. So it's sort of a very clear example of a conditional threat where you don't have to comply with it. There's nothing about pushing snow in front of in front of Kyle's property that he had to do and was therefore imminently threatened by it. And I get, we're spending a lot of time on this. My point is, in this particular case, words matter. Let me also just talk about the law, doesn't take away all options. I think we talked in Blood Deer about sticks and stones can break your bones, but words will never hurt you. And that's a kindergarten notion of it. And we accept that in the real world out there, words can be scary. And threats that you probably don't hear in kindergarten, like, I'm going to kill you and your family, didn't come around. So there is another layer. And it's this. You're allowed in New Hampshire, under the same justification self-defense law, a person who responds to a threat, and this is as opposed to imminent deadly force, to a threat which would be considered by a reasonable person as likely to cause serious bodily injury. In other words, the basis of the threat is something like, I'm going to kill you. You can respond to that by displaying a firearm or other means of self-defense with the intent to warn away a person making that threat and you don't commit a crime. The law has anticipated this very moment where it's just a threat, but not imminent use of actual deadly force. But the threat of deadly force, if you're armed, you can produce your firearm and say, no, you're not. It says nothing about then being able to shoot them for retribution, for your anger, for your offense, for your sense of honor. You can warn them away if it's a threat. And to be clear, Jason Levesque never claimed a standalone threat. He got up on the witness stand and made that claim because he's got to. He's got to get away from this notion of conditional threat, got to get away from the notion that he was just entitled to brandish a firearm. He got up there and said, after the nose-to-nose encounter, he walked away and said, you don't believe me? I'm going to kill you. Here's the problem with that. It's a credibility issue. When he talked to the detective, he didn't say once, he said twice, in clear terms. Again, this looping effort to clarify, is he committed to this specific issue or not? Said he stepped away, he was walking back towards his house, it was after the gesturing, and Kyle turned at some point. You got to ask yourself, was that in response to the defendant saying something? Because his response, according to the defendant that night, was simply, what, you don't believe me? And that had him walking back, sounding very much like an exchange. The bottom line is, no, there was never an additional standalone threat despite his claim. You saw this process work out, how it works. I showed him the transcript, 2 places where it was very clear that there was no standalone threat, and he said, oh, it's in there. If it was in there, you saw the process work out. His attorney could just as well get up there and show the transcript where I was being tricky and omitted it and say, oh, no, here it is, but that never happened. The reason that never happened is because it's not in there. Jason Levesque never claimed there was a standalone threat.
Jen, congrats on 20 months. OG! Thank you.
As I say, there's nothing appropriate about that threat, but Jason had legal recourse to brandish his firearm. Does this case change over his claim that his daughter was threatened? It doesn't. The same reasonableness, the same imminency of deadly force would have to necessarily apply to the daughter. And here we know, I'm not saying it's appropriate, but here we know that he never used even the term daughter. We don't even know that Kyle was aware that she was in the truck because he never gestured towards her, never pointed towards her, never invoked her name, or even specifically daughter. It was a broad brushstroke, horrible, inappropriate threat, but not one that imminently targeted his daughter, not this case. We talked in kind of candid terms during voir dire about whether threats change for you if they concern your family. And of course, everybody's initial visceral response is, yeah, you threaten my daughter, I'm going to kill you. And that may well be, a natural initial reaction. But this is for real here. This is now the application of the law and the consideration of real-world consequences. It's not a conversation with, your friends and family around the dinner table. This is what I'd do if somebody said that. This is the realization of what actually happens, when you shoot somebody.
Careful, camera, careful.
To being offended, to thinking there's some street notion of retribution.
Almost saw the jury there.
This is real world.
Curly Q NPR, welcome to the gallery. Thank you.
Real world standards.
You're one of us now. You can never leave.
What happens next was the walk away and return. The walk away is important concerning, again, 2 issues: time, space, opportunity, diffusion of risk. Kyle walks away at least 15 feet away. The nature of the threat necessarily diminishes. If he has a screwdriver, that is, sort of fancifully filling Jason's mind. He hasn't not only referenced it, it's purely fanciful. It's not a reasonable belief, but from 15 feet away, screwdriver isn't going to do much good. This whole issue of, he didn't go through a mag detector, so Jason didn't know whether he had a weapon on. There's no reasonable basis. He didn't reference a weapon. He didn't display a weapon. He saw his hands clear. But here's something to consider. What Jason Levesque knew was that Jason Levesque was armed. In other words, from that distance, he could have easily, if he was really concerned about imminent use of force from some weapon, he could have drawn his weapon. And at that point, still, he does not. Kyle is gesturing to the snow, gesturing back, really corroborating, if nothing else, just his conditional threat that that snow needs to be moved before we have a problem. He turns back to his own house, and as I said, there is no new threat. His hands are in the open. But he does clearly walk back towards Jason. Response to, again, a comment or an exchange. We don't know because we can't pick it up on the audio. And then again, he brandishes the firearm. And the state concedes he's within his rights based on that threat statute. They said you can brandish it to a threat. You can't use it unless there's imminent deadly force. And here's where things go south for the self-defense claim. This is the ace, the second ace. It worked. Brandishing the firearm worked. You can see Kyle Violette stopped. And it's not milliseconds before he was shot. There is time. Revisit this on the video, and I don't mean in a hyper-technical sense. View it from the claim that Jason Levesque is making. Oh, this was a millisecond. It's not. He pulls out his firearm back by the plow, and he starts closing the distance, clearly indicating he knows he's in control now. You don't close the distance if you're afraid somebody's going to break out a weapon, a throwing screwdriver, or anything else. He closes the distance, raises the firearm, and with unambiguous certainty, Kyle Violette stops. And he doesn't merely stop. He turns away. And you can see this from multiple angles. You can see this from that garage view. You can see it from the side of the house view. You can utilize that evergreen where you see him just come into view. Gun comes out, and he goes out of view. You can see it from the porch perspective, which is down at the feet, imperfect. But critically, what is visual is that his feet become reoriented, stepping away. Both feet are now oriented to across the street. He's clearly turned. This is before he's shot. That's time. Opportunity to see the threat diminish, to see that the brandishing of this weapon accomplished its end as justified in the law. And yet, he closes on him and discharges a firearm into his head, into his face, crashing through, smashing his jaw, and dissecting his carotid artery.
Tammy Schulte, welcome to the jury. Thank you so much. Make sure you take your reserved seat,
unnecessary, unreasonable, unjustified. An unarmed man stopped and turned away from his gun and tried to kill him.
It's a very good closing.
The next 5 rounds.
He's good at this.
He shoots him in the back. The time frame is something like, and you can listen to the video from across the street that's just audio. It captures the first gunshot clearly. And do the count. Something like 4 to 5 seconds. Think about that. 1001, 1002, 1003, 1004. Bam, 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 bam. It's unconscionable. He's on the ground, crawling.
He missed one of the bams. Bam,
for his
bam,
life.
Bam, bam, bam.
That's attempted murder. By the grace of God and the intervention of immediate medical assistance, he lived. But that's attempted murder. You know, this is an incredible claim that we heard yesterday. You know, I asked him, do you think he's still a threat to you? Yeah, he was crawling towards my parents' door. Literally said that. That's incredible. It's like the cyborg scene out of The Terminator where the thing is crushed and still crawling on the ground and it's, you know, pursuit of murder. Except this isn't science fiction.
Bingo.
The fiction here is from Jason Levesque that
I had cyborg.
Kyle crawling on the ground with a nearly lethal, certainly would have been lethal without intervention. Gunshot wound to the head presented some sort of threat to him, his family, or anybody else. The other thing he's crawling towards is his home. And that's obvious. And once again, we know there are other factors to show that Jason had no sense of impending threat or injury to him. He lowers the gun. You can see that in the
mixing
video.
Up the names.
He lowers the gun before he advances some 3, 4, 5 steps closer to the supposed threat before he unloads the additional 5 rounds into his back in lethal fashion. Look, you got to analyze that in terms of reasonable force, reasonable belief, and the imminency of threat. These are the moments. It's not the nose assault. Let's talk about intent to kill. We need to prove that. You can form a purpose within the meaning of the law in a moment's time. You need to have the conscious object of a certain result. There are plenty of practical examples of this, of bad decision making or regret doesn't take away the purposefulness of a decision. Geez, I shouldn't have had that extra martini. That didn't mean I didn't take out a shaker, a glass, pour gin into my martini glass. I may regret that, but I certainly still acted purposely. It can happen in a moment's time. A decision to pick up this glass or that glass is still a conscious object and a decision. Here the steps, though, are much more conscious and involved. Each act, purposely, to take out the gun from a holster, to raise it and aim it, to advance towards a target to ensure greater accuracy and lethality, to pull the trigger, to watch him fall, to watch him crawl, to advance on him, to aim again, to pull the trigger each time. This is not an automatic weapon that just sprays out 6 bullets. Each time he pulls the trigger is a purposeful, conscious act seeking to create a result. That's an ace.
Now we've got 3 aces, right?
Look at the nature of these wounds. A headshot, 5 additional shots that each found potentially lethal marks. He's got shots in both buttocks, clearly indicating he's not a threat, but all those shots were potentially lethal. You heard the doctor say that each one was in an area of critical vascular, nerve, and organ systems. One of the bullets through his buttocks blew out his abdomen, dissecting his bowel, requiring emergency surgery. Need I go into the details of these images, which the defense on the one hand dismisses as unnecessary, but at the same time, Jason Levesque gets up there and he is asked that critical question: why did you shoot him? Did you intend to kill him? No, I just wanted to stop him. Look at those images. Play that body cam of Sergeant Hurley saving his life, and you got to ask yourself, is that the intent of somebody just trying to stop somebody or kill them? That's an ace.
That's 4 aces. Any more than this, we're cheating.
Let me talk about Jason Levesque's claims that he made to Detective Garson. Confusion, memory, tiredness. Look, these lies that he made, that we talked about, were central issues required for self-defense. He didn't just happen to, stumble upon some misstatements. These are not the misstatements of, confusion, misstatements of fatigue, like his distance was off, fibs to cover for his pride or embarrassment. They are essential features to support a non-existing self-defense claim. If you had a bad memory, you were so confused or overwhelmed, you'd say to the officer, you know what, I don't remember that. I don't remember that moment. I'm confused about that moment. But he never said that. Instead, in response to Garson's questions about, well, what happened after you took out the firearm, he gives a vivid, a pictorial account, a visceral account. He said, I took out the firearm. Did he stop? No. He continued to advance towards me. In fact, he hastened, his words, hastened his pace towards me. It had been 10 feet away, but then he rushed. And I could see in his eyes his aggression. All of it, complete fabrication and nonsense, but all of it essential for a self-defense claim. So what did you do? I fired. Stay on his feet? Yeah. That's not confusion. Confusion, I don't know what happened. He gives a very precise answer. Why? To justify the next 5 shots. Did he go down? No. He didn't appear to flinch. Maybe he flinched because of the noise. But I don't know if I even hit him, because he kept coming at me. Well, then what happened? That's why I had to unload those next 5 rounds. That's not confusion. That's not, I'm not sure what he was doing. He's coming at me. And he gives this vivid, nonsensical. The degree of mendacity is breathtaking. He literally says, I shoot him 5 times, and he holds his abdomen and turns away and walks back to his home. That's a self-serving lie to fabricate self-defense, because he knows what he did was wrong. And to justify. Otherwise, we'd see kind of this random confusion of facts that some support, some don't make sense, some aren't corroborated. But it just happens to be that each lie is such a divorced distance from truth and happens to land squarely within a set of facts that would support self-defense if true. But we got some aces. We got videos that demonstrably show he's lying. Let me talk about some other aspects of the defense claims. That he was tired at the street side and therefore was having difficulty. We've got to adopt this 40 hours of sleep. First of all, that whole notion that he was up for 40 hours is a credibility question for Jason Levesque. He's working for a commercial plow company that has some liability, and you think they don't give him breaks over the course of the day, that they're not conscious about the amount of time somebody's on the road. He's operating a commercial plow where apparently even at that hour he is able to make precise judgments and assessments of distance, of force, to plow, to pick up his daughter, drive safely there, but he's too tired in the next 5 minutes to make rational assessments about risk and whether or not the Kyle is on his feet or not after getting shot in the head. Let me just say, he's not tired in the sense that that he's absolved of responsibility. He may be sleep deprived and dangerous, but that's a different matter. How about that he consented to the videos? Look, he's sitting there in there's another immunity card from the defense. Well, he gave him the video. Look, Garston heard about the video earlier on. He looped back at page 66. He hears about it at page 27, but he's the one who says, hey, you got video from tonight? And it's true, the defendant signed over the video. Do we know whether he's thinking, hey, maybe there's a Hail Mary here, that there is a kind of a perfect convergence of omission? It was pretty close. I mean, one of the videos just has him coming into view. The porch video is facing down. The garage video has only the sliver. And do we know whether he's making that calculation or not? I don't know. But we know he couldn't count on 43, pulling it all together, getting that arc of a view, that if you see these things in conjunction, you know that Kyle Violet stopped when the gun came out. You know, with the totality of these videos, that he was closing the distance. You know that there was sufficient time between brandishing the firearm, Kyle stopping, and pulling the trigger to assess risk. You know he went down after the first shot, and you know he came over to try and execute him with the next 5. That he gave them that video doesn't change any of that. Those are 4 aces. I hope he doesn't do anything stupid. Look, you want to talk about red herrings. Let's assume he's talking that she was talking about Kyle. Stupid doesn't mean that he's going out there. What she doesn't say is, boy, he's armed and dangerous. I hope he doesn't go out there and kill him. Stupid is going up and putting your nose in somebody's face and making a horrible threat that could have resulted in him brandishing a firearm or getting punched in the nose. But nothing about, geez, I think he's going to go out there and kill him.
State admits she lied on the stand.
Let's talk about this repeated mantra claim from the defense that Kyle Violet is a lunatic, a maniac. Look, maniacs run out into the road with a bloody axe and threaten you. Here, let's not forget the actual facts here.
Yeah, I've seen them.
And they want to omit, the prior event with the snow to make him look like a maniac.
That's insane clown posse.
You heard from Kyle's daughter. That's got to be one of the most objectively grounded, reasonable, pleasant witnesses we've seen. And she described being at home with her dad, who she adores, and planning a family night, sitting down at dinner, planning to watch a movie, but everyone went to their room, and they were getting apprehensive about the plow not showing up, and that they were all going to have to get out there and shovel, and the anxieties went up. And even Kira, Jason's daughter, acknowledged that, the first storm, we did plow in front of his place. And they did say something. We said, it'll melt. And so there was anxiety about that. I'm not suggesting, again, that the threat is reasonable. I'm suggesting it's not maniacal, that there is context for this, that there's history for it. Don't put that in front of my driveway again. It sort of diminishes the maniac view of this, doesn't it? And likewise, let's go through just some of these other efforts to assail Kyle's sort of humanity. The so-called prior event. What was that about? Talk about innuendo. I mean, we had, once we got into the detail of it, it's like, well, who is this guy? I don't even know if he was my neighbor. I couldn't pick him out of a lineup. Did you call the police on Kyle? No. Did you see Kyle again before this? He might have been taken out of his trash. You can't even identify that dude. And they're bringing that forward as some sort of an assault on his character to create an image in your mind that is much different than the guy who was having a family dinner and got anxious about having a hand remove snow. That's not fair. What about the claim that when Jason returned to his vehicle that he told a joke about running? That is more breathtaking mendacity. Somebody who just shot somebody this side of death can't possibly tell that kind of a joke unless they're a sociopath. And you know what? He has to recast it again, very much aware of his self-defense claim. If he got up there and admitted, yeah, I was thinking of running, it's an admission that he knew what he did violated the law. Because only people who violate the law and want to avoid legal recourse and consequences run. The first thing he says to his daughter is, should I run? Too. And this isn't just a passing, moment. You heard what Kira had told the police. He asked me, should I run? I said, no, you can't run. And he doesn't stop it there as a ha-ha joke. He says, well, then what should I do? Her response is not, oh, ha-ha, you're joking. It's, this is your path. You've got to figure this out. Should I call 911? I don't know. And no, he doesn't. That's not a joke. That's an admission of a guilty state of mind immediately after these events went down. I'm in trouble. Not because he came at me after I brandished the gun. Not because he continued to come after me after I shot him in the head. Not because he continued to be a threat lying on the ground, bleeding to death from a dissected carotid artery. Because he was in trouble. He wasn't justified in shooting him, and he knew it. And that brings us to the police station where he contrives these litany of self-serving lies. We had heard in opening that, if Kyle wanted to kill him, he could have. He could have gone back and got another magazine. These images depict Kyle's intent. Excuse me, Jason Levesque's intent. Kyle Violet was
how many times I mix up the
as
two.
close to dead as you can get without a funeral. This is the intent to kill. There was no discretion on the part of the defendant to temper his use of violence. You got to weigh the reasonableness, the degree of that violence in light of the actual evidence. Take a look at it.
They each get an hour, so he's probably halfway through.
I want
Maybe a little more.
to talk briefly then about this notion of Kyle's actions that create then a reasonable belief. He's on the ground in one instance and stopped in the next. And now you've been invited to view Jason's perception of that and to simply accept that whole plot. That's not the standard. Jason needed to have believed he was in imminent threat of receiving deadly force. We know he wasn't because he was in control of the firearm. We know he wasn't because Kyle stopped. We know he wasn't because Kyle was crawling for his life when he received the next 5 rounds. But so that's the first prong. Even if you get there, you do get to evaluate this objectively to determine whether it's reasonable. And to dismiss it simply because he was tired is not the law. If he was tired, he should have used extra caution and care with a firearm and the actual use of.
He's got about 5 minutes left, 4 minutes left.
Being fatigued is not an immunity card. It doesn't dispense with objective notions of reasonableness. We literally heard from Jason Levesque up on the stand that, you know what, I don't even know what self-defense is. You lawyers getting tricky on me with this defense notion, self-defense. I didn't know what it was, therefore I couldn't have been contriving it. Here's a guy who explained that he carries a weapon because of a prior incident with some machete. Of course he knows what self-defense is. He literally explained. That's why he carried. And yet, we're supposed to believe he's too confused, too ill-informed, too tired to reasonably weigh out self-defense. He knew self-defense, and that's why he lied. He knew self-defense, that's why he carried, and was supposed to carry responsibly. Look, ladies and gentlemen, I want to sort of address and end on this issue, another concept that we heard in opening statements. At one point, Attorney Sisti said, basically, this is the theory of the case. Kyle Violet got what he deserved. You know, first of all, to assess that, you got to take a look again at what Kyle got. And it's in these pictures. This is what Kyle got. And it was all from words. Grossly inappropriate words, but words nonetheless, not married to, not advanced by actual threats. And it is, you know, at this point that we invoke justice. That, I told you at the outset, it sounds kind of corny, and if I said this around my Thanksgiving table, I'd be asked to leave, but embedded in our civic duty, our civic culture, justice is sacred. The process of achieving justice is embedded, provided for in our Constitution, a process of determining justice. And it doesn't require that you abandon, as you've been invited to, scrutiny of Jason's actions, that the frame-by-frame viewing of whether he stopped or not is unfair. Because that's exactly what we do. We don't, you know, get shamed away from judging these kinds of actions. What we do to achieve justice is, in fact, invoke this process. The prosecution has a burden to come in and present evidence to a group of citizens, jurors, who take an oath. This process makes our system of achieving justice probably the best in the world. Not perfect, but probably the best in the world. You evaluate that evidence in light of our burden, but using your individual and collective common sense and apply the law. You do that in this case. The path to justice is, in fact, guilty verdicts on both indictments.
Guilty verdicts on both indictments. I ask you to endeavor on that path. Finished right at noon.
All right, well, ladies and gentlemen, as you can see, we've now reached the 12 o'clock hour. It's been a long stretch of sitting. So I'm going to take this opportunity for the lunch break. We will take the 1 hour lunch break. We're going to come back here. At that time, I will instruct you on the law. That takes a little bit of time. It takes about 20 minutes or so for you to do that. And once I've done instructing you on the law, then you will have the opportunity to deliberate on the case. So you're not free to deliberate yet, but you are free to go have your lunch. So could we be back here? Oh, 1 second. One question.
I've got a quick question. We are not going to listen to jury instructions. We're going to jump back over through Portal to North Dakota. Man, we're back and forth, and it's podcast day too. It's gonna be nuts. But let me just check and make sure there's nothing else that happens here before the jury leaves. Before we head back over to North Dakota, where testimony is resumed.
And I'll charge you, and then you can begin to deliberate. All right, so you can't deliberate yet. I apologize for that, but that's where we are. All right, thank you. Can the jury be removed, please?
Get that jury out of here, says the judge. Get him out of here. It's lunchtime. And with that, we're going to go ahead and Portal. You think you know how to do this well, right? You've done this many, many times. We're doing it a couple times today. We're going to Portal again. Basically, that tells us that the jury is deliberating right now, I think. I think they're deliberating right now. Looks like they're deliberating right now. So, sounds good. All right, we're going to Portal. We've already got the new landing spot. I have to do that one.
It's bigger than you. It's bigger than me. It's bigger than all of us.
It's bigger than all of us. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe to go live again in moments. Back in North Dakota for part 2 of day 3 of the Nichole Rice trial. The bad roommates. From bad neighbors to bad roommates. Back and forth we go. And at some point, I'm going to have to tell you what's on my desk. I will deal with that later. All right. Everyone, hang on. Grab your portal buddy. We're going to jump through the portal here now. We'll see you in a bit.